Hello, everyone. My name is Wendy Barlow. I'm from Cohen, Tucker, and Ades. Just coming on today to discuss with you a few recent USCIS policy changes and rule changes that will impact a variety of different applications. So I'm going to jump right in and start with premium processing. USCIS just announced new rules regarding premium processing that will expand the program. For example, you'll now be able to pay premium processing fee, additional fee for premium processing on some applications to change or extend your status. So for example, if you're here as a tourist and you want to change to a student visa or student status, you'll be able to pay an additional fee and have your application processed faster. This is not going to be available for every change of status, but it's going to be available for expand the program to cover most changes of status. What will it look like? Well, you're going to pay an additional fee of $1,750, and then you will get processing in 30 days. Also, what will be done is a expansion of premium processing for extensions. Again, like I said, it's not going to cover all extensions, but extensions like E2, H4, you'll be able to pay an additional fee and have your extension processed in 30 days. In addition, they're also going to allow premium processing for employment authorization documents. Right now, if you have an application pending, you know it can be taking anywhere from a few months to over a year right now to get a new employment authorization card or to renew an existing employment authorization. Now, premium processing is going to be $1,500 and give you the ability to get the application processed in 30 days. This is great news if you can afford to pay the additional fee. Also, some good news is even if you can't afford to pay the fee, USCIS is currently in the works to change automatic extensions for some employment authorization document holders. So for example, if you're in a category right now that currently when you're renewing, you get an automatic extension of 180 days, they are looking to expand that. The rule is not in effect. It hasn't fully been proposed, so I can't give you more, but it is something that's in the works. Last but not least, regarding premium processing, they're going to expand it to different I-140s. Right now, if you're doing an immigrant visa petition based on an employer and you're filing under the intercompany transferee for managers or executives, right now you cannot premium process those cases. Premium processing is also not available for those with advanced degrees and those seeking national interest waivers. In the future, that is going to change and it will become available. However, the cost will be $2,500 and the premium processing will be 45 days. So it's not going to be like existing premium processing where it's you pay $2,500 and get 15 days, but it will be 45 days, which again is a lot shorter than the current processing times. So that's pretty much it for the expansion of premium processing. Those rules are not yet in effect, so don't rush to start paying USCIS extra money. They will take effect in approximately 60 days. If you have any questions about whether you're eligible, please contact our office and we will be happy to discuss it further with you. Now, next topic. USCIS has also recognizing the substantial backlogs they are currently facing with all applications and petitions are now creating new case processing time goals. Now, that does not mean that these will be written in stone. So the fact that they say they're going to process cases in 3 months does not mean that that's what the reality of the situation is. These are the goals they are trying to hit. So moving forward, they are trying to get to a position where employment authorization document applications are processed in 3 months. Again, that's going to not happen overnight. It's not going to happen in 30 days, 45 days, but these are new goals. They're also going to try to get adjustment of status and naturalization applications processed in 6 months or less. These are lofty goals. They are achievable, but they are very lofty goals, especially considering everything that's currently happening at the agency. It is going to require additional staffing. It may also require more Saturday interviews, which are still a thing, but it is progress. They are at least recognizing the significant backlogs and trying to take action to improve them. And the last rule change that I'd like to discuss briefly is rules applying to applications for asylum. We've been getting a lot of calls recently regarding this. There are going to be some changes into how applications for asylum are processed, but it is important to note that this does not directly impact the majority of applicants. If you are someone who entered the country with a visa, or even if you entered the country without inspection, meaning you crossed the border illegally or without permission and didn't get caught, these new rules will not directly impact your application. You're still going to file with USCIS, wait for an interview at the asylum office, and proceed from there. Who they will affect is those who are stopped and subject to expedited removal. These are people typically picked up at the border, or those who may present themselves at the border, or individuals who are stopped at the airport for a variety of reasons, found to not be allowed in the country, subject to expedited deportation, and then turned around and telling officers they have a fear of returning to their home country. What's going to happen with these applications is if you pass what's called a credible fear interview, and this is an interview by an asylum officer just to assess whether or not you have a likelihood of being able to show you're eligible for asylum at an actual full-blown interview or hearing, you will now have the opportunity to have your application adjudicated by an asylum officer. Right now, let's say you were stopped. You were told, we're expediting your removal from the country. You tell the officer, I can't go back to my country, I'm afraid. And they say, okay, you're going to have a credible fear interview. If you pass that credible fear interview right now, what happens is you're scheduled for, you're putting removal proceedings before an immigration judge, and you're scheduled for a hearing on your asylum application. If what's going to happen moving forward is that these individuals will be allowed to go to the asylum office. This will ultimately help speed up processing of these applications. It will also take some of the burden out of the immigration court system, because if the asylum office approves it, the case no longer needs to be dealt with the immigration court. Now, I know I said no direct impact on people who are filing affirmatively, who either entered with a visa or without, and just were not subject to any kind of CBP or ICE intervention in their entry. It is going to help overall with the immigration court system. The less cases going to the immigration court, less cases that are there, the more hearings judges can conduct expeditiously. Again, these are all things that are going to take time when implemented. They're not going to fix the problems overall and overnight, but they will eventually start relieving some of the burden on the courts, which will allow the judges to handle cases that need to be in front of them, that there's no other reason except for the way they entered the country. This is the only reason they're in front of the judge. So it will have a good impact overall. That's all I have for today. There are lots of things happening every day with immigration. It's hard to, put them all in a video that's not hours long. So we try to focus the topic. So today was USCIS changes. But of course, if you have a question related to what I've talked about today or another immigration matter, please do not hesitate to call our office. The number is 212-840-0050. We'll be happy to set up a consultation, in-person, video, phone, to discuss your specific unique questions directly. Thank you and have a great day.